Hello, this is Della Welch again, attorney at law. As I stated before, I've taught law for 35 years and have been able to simplify the law. My last tape was tape 1 on contracts. That was the offer, acceptance, and consideration. We'll start out with a little review, for a short review, and then I'll go to defenses. Remember that on an offer, one had to have present intent and not wishy-washy words of preliminary negotiations. And also, definite and certain terms are needed. And the terms are for parties, subject matter, time, and price. We'll later learn about UCC 2-207 and provisions of sales law that make a difference in this area. And then the offer had to be communicated. If I said to my students, I will give you $50 if you type the midterm, but I put it in a letter that I kept in my purse, then the offer was never communicated, and it would not be an offer. An acceptance, the mnemonic, which is a memory device, is CUT, C-U-T. It must be communicated. It must be unequivocal, meaning you don't change things. And it must be timely. And then also remember the general rule that silence is not an acceptance unless there's been some pattern of dealing where a merchant sent goods and the other merchant always kept the goods and remained silent. So that would be an exception to the rule that silence is not an acceptance. Now, this lecture is the list of defenses. A big one is incapacity. Certain people, because of age, because of mental faculties, or because of intoxication, cannot make contracts. We'll learn of that. And then we'll learn about duress. There can be physical duress. Suppose someone wants to buy another person's bicycle and the person does not want to sell the bicycle. And so suppose the other person beats up the bicycle owner until the bicycle owner says yes. Well, there would be a defense, which would be physical duress. Another defense would be illegality. Suppose someone is buying cocaine from someone. Well, that's illegal, and that's a defense. And then mistake. There's a very famous cow known always to law students. Her name was Rose of Avalon. And what happened is one farmer agreed to sell Rose of Avalon to another farmer, and both thought the cow was sterile. In truth, Rose had a little trick up her sleeve, and she was pregnant. So when the farmer went to deliver the cow, he found out that she was pregnant. Well, the farmer did not have to deliver the cow because of the defense of mutual mistake. They both bargained for a sterile cow, and in truth, the cow was pregnant. So this was a mistake which was basic to the subject matter of the contract. And then we also have a very big defense is statute of frauds. Certain agreements might be easily the subject of fraud, and so we need to have a writing or an exception to make them enforceable. If we don't have the writing or an exception, they're like a toothless smile. They don't amount to very much, and the law will not enforce them. The mnemonic for that is M-Y-L-E-G, or my leg. The M stands for contracts in consideration of marriage. Suppose that the new father-in-law is going to give the married couple $50,000 for a wedding gift. Well, that would be a contract in consideration of marriage, and that would need to be in writing. Y is contracts that by their terms cannot be performed within 1 year from the date of the making. Suppose that it's January 1st, 2017, and we're both at the Rose Bowl, and you say to me, I understand you have a home in Orange County. I would like to rent that for $2,000 a month. And I do not want to move in or have the contract start until the March 1st date of 2017 for 1 year ending March 31st, 2018. Well, how long is it from the date of the making, January 1st, 2017, to March 31st, 2018? That would be 1 year and 3 months. So that must be in writing to be enforceable. So that's the Y. Contracts that by their terms cannot be performed within 1 year. L stands for land. Contracts for land or interest in land. If you call me and say, I want to buy your home in Orange County for $500,000, if I said yes on the phone, that would be oral. It must be in writing to be enforceable. E is excess of $500. Contracts that the price is in excess of $500. If I go to a department store to buy a brand new TV for $1,000, that would be a good in excess of $500, and I would need a writing. And then G is contracts to guarantee the debt of another. I call that a cosigner. That is a very serious situation, because if you cosign on a car and the other person doesn't pay, then you are responsible for the money. Now, there are some exceptions. A person in their pleadings might make an admission of the contract. That would be sufficient to satisfy the statute of frauds. And then also, there may be a memorandum or a series of memorandum of essential terms, and it's signed by the party to be charged or the party against whom enforcement in the case is sought. In such case, that would satisfy the statute of frauds. So the statute of frauds is very important, and then it's also important to know the exceptions. Now we get to a little more about those who lack capacity to make a contract. If they're people under age 18, or if they have mental incompetency, or they are intoxicated, we look at their capacity at the time they made the contract. If there has been an adjudication that this person is insane and they get out from the rest home and make a contract, that is void. If they just dip in and out of capacity, then they can affirm or disaffirm the contract when they gain capacity. And it's called voidable. A person who enters a contract at age 17 has until 18 or a reasonable time thereafter to ratify or agree to accept the contract. And in terms of intoxicated persons, when they sober up, they can either accept the contract or disaffirm it. It's voidable. So mental incompetency is a very big issue and should be reviewed.